Please be seated. The court is now in session. Today we will continue to hear the testimony of the witness Steve Heather, who will be questioned by the defense teams. And before we commence that proceeding, Mr. Dutpari, could you report the attendance of the parties to today's proceeding? Dutpari, Mr. President, for today's proceeding, all parties are present. It should be noted that Nguyen Chi is present in the holding cell downstairs, pursuant to the decision of the trial chamber concerning his health. The witness, Mr. Steve Heather, who's going to continue to testify today, is already present in the courtroom. Thank you. President, thank you. And before I hand the floor to the defense teams, the chamber would like to make the oral affirmation that we have made on the 18th April 2012 regarding the decision of the accused to exercise his rights to remain silent. By motion dated 5th July 2013 and notified on Monday, the 8th of July 2013, the Khieu Samphan defense team notified the trial chamber and the parties that the accused Khieu Samphan would no longer answer questions before the chamber. In response, the co-prosecutors proposed several concessions intended to facilitate the preparation of the Khieu Samphan's defense for the questioning of their client. Otherwise, they requested the chamber to warn the accused Khieu Samphan of the legal implications of his decision to no longer answer questions before the chamber. The chamber has decided, in the light of these submissions, that it should recall its prior oral ruling on this issue made on 18th April 2012. And now the chamber would like to give the floor to Nguyen Chi's defense to put questions to the witness, Mr. Steve Heather. You may proceed.
Thank you, Mr. President. Good morning, Your Honors. Good morning, Counsel. Good morning, Mr. Heather. Mr. President, before I proceed, I don't, of course, need an answer immediately. But I would like to bring your attention to the fact that the prosecution and the civil parties have been questioning the witness for 3 days minus 30 minutes, 35 minutes. It would seem that we need more time to ask questions to this witness, more than the day that was allotted. Now, I will do my very best, nevertheless, to stay within that day, but if that won't be possible, I, of course, would like to be able to use an opportunity to go into the next 1 hour and a half of tomorrow. I just would like to give you advance notice of that possible request, which might follow at the end of the day.
Yes, good morning, Mr. President. Good morning to the Chamber and to all parties. As of now, I would like to state that as far as we are concerned with the Quai defense, the 2 days seem insufficient to us to treat all of the topics that have already been covered by the co-prosecutors during their questioning, as well as by the civil parties, contrary to the Chamber's habit of giving equal time to all teams. And for Mr. Heder, we were told that we're only given 2 days, but given the recent developments and given the time extension that was allowed for the co-prosecutors, you may understand that as far as we are concerned, given the massive documents that will be considered, we also will need to go over a certain number of documents again, and that will take time. And since the Quai team is always the last one, or often the last one to speak, especially when maybe the Chamber becomes a little bit more impatient, I wanted to let you know that as of now, we will also require a full day and an extra hour and a half, which will represent 2.5 days total for all defense teams. So I wanted to make this specification as of now so that no one is caught off guard and to prepare the Chamber psychologically for this new situation.
President, the Chamber will take up on the issue, and we will see how we go, and also it's based on the nature of the relevancy of your questions to the witness. And if the Chamber deems it is necessary to extend the time, we will do so. You may now proceed with your questioning, counsel.
Thank you, Mr. President. Once again, good morning, Mr. Heder. You've been hearing 3 days of questioning from the prosecution and the civil parties. All the questions were put to you in your capacity as a witness. You've heard numerous objections from the defense when the defense was thinking an expert opinion was solicited. But the question that maybe a lot of people would like to ask you hasn't been asked yet. You have been summoned as a witness because, as I have understood, you have refused to appear as an expert. You might be aware that the trial chamber has considered you to be an expert on the relevant matters. In the words of the prosecution, you are indeed the world's leading academic in respect of the CPK and its policies. My question to you is simple. What made you decide not to want to appear as an expert?
There are some interrelated reasons. It's indeed true, if I understand it correctly, that the trial chamber considered me as an expert. And I guess defense, through its submission, did so as well. However, when I was assigned to the Office of the Co-Investigating Judges, I was definitely not considered to be an expert. Judge Lamond once remarked to me that I'm the expert. That is, Judge Lamond is the expert, not you. And there's a level at which, well, so to my legally untutored mind, it seems to me there's some dispute about this. approach the question in my capacity as a scholar or an academic, which may or may not be the same thing as an expert. It's no accident that, generally speaking, I think most academics don't express themselves nor expose themselves to situations in which they express themselves, as it were, for the record, in a question and answer format. I don't want to go into things about intellectual snobbery and all of that, but the normal mode of academic expression is through published materials. And there's a process by which those published materials are produced. You write something, you read it, you think that's crazy what I wrote. You revise it. You read it a couple of more times, you revise it a couple of more times. You send it out to your peers who are friendly, or at least whom you feel you can rely upon not to betray some confidence or to act in a hostile manner in your regard. They make suggestions about what you should maybe read additionally or think about additionally, or what seems to them not to make sense. And then you send it off for publication. And at that point, it's sent around for peer review. And at that point, you might get some very hostile but anonymous commentary about your work, which you often have to take into account before you publish. And then finally, after a process that may take months, if not years, depending on the length of the piece, with luck, it sees the light of day. And at that point, it's in the public domain, and it becomes the subject of academic debate. And it's that sort of that last stage, which is the, as it were, adversarial part of the process. And to my mind, that's the right format for an academic or a scholar to express themselves, not in the question and answer format to which I'm being subjected, or which I've being given an opportunity to have in the court. So I would rather express my expert opinion, if I have an expert opinion based on my scholarship and so on, in the proper academic mode. And in that regard, I would note that regardless of debates about procedural issues and the actual substance of the resulting work product, previous experts, or people who've been considered experts, people like Craig Etchison and people like the demographers who did the demographic report, followed more or less that route. They were commissioned by somebody or another within the court to write about something. I'm sure they sat down and they drafted it, and then they redrafted it, and they redrafted it yet again. And then it was submitted. And on the basis of what was submitted, they were then questioned. And that seems to me to be a better way of soliciting an expert opinion. That takes me to, taking time, takes me to my second point. That process obviously takes time. In other words, if I was going to do something like that, I would have wanted to have had several months at least to prepare my report. I wasn't asked to prepare a report for whatever reason. If I were to be asked to prepare a report, as I said, it would take me probably several months in my mind to do it right. And that takes me to my third point, which is sometime around the end of 2011, I decided that I no longer wanted to have all of my intellectual and other energies focused on the Khmer Rouge. You know, when I first started looking at the Khmer Rouge in 1973, it was current events. I've always been interested in current events. I'm a political scientist. I've taught the whole of Southeast Asia. And while you all, or most of you all, were undergoing this steep learning curve about the Khmer Rougean power, I felt myself being de-skilled in terms of the rest of my interests and qualifications. So around the end of 2011, I decided no more Khmer Rouge for now, and if I may be allowed to say so, decided no more Khmer Rouge tribunal forever. And that was because I wanted to concentrate on other things. And if you look at my recent proper academic publications, none of them are about the Khmer Rouge anymore. They're all about contemporary Southeast Asian politics. So for those reasons, all combined together, I, as I put it in my email, respectfully declined to be an expert.
Thank you for that long answer. Mr. Hatter, I would like to take you back to the very first sentence, or one of the very first sentences of your reply, when Judge Marcel Lemonde told you that you are not an expert, but that he is the expert. Do you remember if he gave any arguments supporting that position?
Yes. I mean, maybe not at the deepest level, but at the level of explaining that, in his view, it wasn't appropriate for someone who was an investigator, researcher, analyst inside the Office of the Co-Investigating Judges to also, at the same time, be an expert. And he didn't, at the time, nor subsequently to my recollection, ever, as it were, cite chapter and verse from his legal tradition to back up that explanation, semi-explanation, with a reasoned legal judgment, if you will. But he was very strongly of that view. I mean, Robert Petit also once said something somewhat similar to me, which is, I'm the prosecutor and you're not. So, you know, this was a view that had a certain currency in those two contexts. I don't know, you know, so and again, I'm not a lawyer. I'm not in a position to judge these issues. But if I may, one more point. I mean, I thought a lot about what's been going on back and forth between yourself and prosecution and civil parties, and tried to think about it in academic terms. And it seems to me there are two ends of a spectrum here. One end of the spectrum is what you all, or some of you all, seem to call a witness. And the other end of the spectrum is something that you all seem to call an expert. And to use an analogy, if somebody were to ask me, what time did the sun come up this morning?
President, Mr. Witness, please direct your response only to the facts before this chamber, and also the counsel you are advised to put the questions related to the facts determined by the chamber to be heard before this chamber, and try to use the time allocation for your team effectively. And please try to avoid the repetitious nature of the questions. We only want to hear the facts so that we would use it as the basis for our decision. And for that reason, please direct your questions to the related facts. Thank you.
Allow me, Mr. President, and one more question in this respect. Professor Chandler, who wrote a preface to your book on communism, did appear in this courtroom as an expert. My question to you was the fact that he did appear as an expert, a consideration in your decision not to come as an expert, but rather as a witness.
President, your question is not related to the witness. You are directed not to respond to this question, and counsel, you have been reminded on the relevancy of the questions.
just to make an argument why I'm asking these questions, Mr. President. It goes directly to the reliability or the credibility of this witness, and I think it is also, in the light of earlier questions of the prosecution, only fair to ask what the considerations were. But I will move on and ask the question maybe in a different way, Mr. Hedder. Based on your research, based on all your interviews, based on all the articles that you have seen and read, is Professor Chandler one of the leading experts on the DK period?
President, witness, please wait. The prosecutor, you may proceed.
Mr. President, I object to this question. What it really amounts to is, what's your opinion of, or what's the received opinion of Professor Chandler? If my learned friend wants to quote from a particular part of one of Mr. Hedder's books referencing this question or referencing Professor Chandler, there are in fact many references in Mr. Hedder's books to Professor Chandler. If it's a direct question to a direct extract from one of Mr. Hedder's books, I have no objection, but otherwise this is an opinion question seeking an opinion answer.
I will rephrase, Mr. President. Mr. Hedder, in your book on communism, there is a foreword of Professor Chandler. Can you describe for us why it was he who wrote a foreword to your book?
I think I can do this not by citing my own opinion, but by referring to the opinion of other scholars and particularly historians of Southeast Asia, with whom I've obviously had much contact over now too many decades as far as my age is concerned. I mean, anybody who has been a historian of Southeast Asia, particularly writing in English or French, considers David Chandler the doyen of modern Cambodian historical works. Anyone would suggest that if you want your work to have credibility in the community of historians of Southeast Asia, it is a good thing to have an endorsement from David Chandler.
In the publications that you have read about Professor Ben Kiernan, would you say the same thing as you have said now in respect of Professor Chandler?
No, certainly not in the parts of the scholarly community in which I normally travel. There may be other parts of that community because by its very nature it is intellectually split and full of contestation, where the view might be different. But certainly in my circles, which may be a reflection in part of my own views, likes like, the opinion of his work is not as high.
Is it correct when I say that you have extensively criticized the work of Ben Kiernan in your own publications?
Yes, and vice versa. And that's, as I suggested earlier, that's normal. That's the adversarial part of scholarship, which arguably is somewhat analogous to what happens in a courtroom.
Have you, do you know, read all Ben Kiernan's publications?
Without being churlish, I think I can say he tends to be even more long-winded than me. I can't say that I've read every page of everything he's ever written, but I've certainly read, I think, every page of everything he's ever written about Cambodia.
Now let me, if you allow me, go back again to yourself. Both Keenan, both Chandler are professors. You do not seem to have that title. Would you be able to explain why it is that you are not a professor in political science or political history or something equivalent?
President, witness, please wait the prosecution. You may proceed.
I object, Mr. President, on the sole ground of relevance. What relevance does this have? Only evidence that is relevant is admissible. In my submission, this is irrelevant.
And in my reply, Mr. President, this is a relevant question. It goes directly to the person of this witness.
President, the objection and ground by the prosecution is valid. Thus sustained. Your question is not relevant, and the witness, you are instructed not to respond to the last question put to you by the defense counsel.
Mr. Hedder, have you recently watched a movie called A Day at Portray?
No.
Would you be able, based on your research or academic work, be able to say something about the co-producers or co-directors of that movie, Ted Sambat and Rob Lemkin?
Not a lot. I mean, I think I may have very briefly met both of them somewhere along the line. I can't say I've ever had an extensive or serious conversation with either of them. I've watched the first film that they produced, but not paid great attention to it, frankly. There are some other films that were produced around the same time that I looked at, I think, more carefully. There was a BBC production and also an interview with Nguyen Chia that I had more involvement with. But without the equivalent of the document before me, I'm not sure how much I can say.
One other question, Mr. Witt, is about an academic, and I'm referring to your publication, Racism, Marxism, Labeling and Genocide in Björn Kienen's The Pol Pot Regime. That is document E131/1/131.3. English ERN 00773700, French 00802800, and Khmer 00844.
President, Counsel with the Coupe, could you please repeat the document ID and the EN page again? Thank you. And please make it a bit slower.
It is document E131/1/13.3, English ERN 00773700, French 00802 800 and Khmer 008445550. In the first page of that article, in a footnote, you write that you would like to thank certain people for their contribution to this publication. You mention David Chandler, but you also mention, among others, Laura Summers. Would you be able to explain to us who this Laura Summers is in the footnote that you're referring to?
Laura Summers is someone who was a PhD student, doing a PhD at Cornell when I was an undergraduate there, which would have been in the early 70s, that is before I came to Cambodia in 73, and subsequently has taught in a number of universities in the UK. So she was in the UK, or coming and going from the UK, at the time this article was written. Her PhD work was on Cambodia. She also did a translation of Kyo Sampan's dissertation with an introduction, giving an analysis of its significance, historical, political, and otherwise. So, in short, she's a fellow academic.
Thank you.
Now retired.
Now retired, I heard you say. Let me get back to a question on your personal background, Mr. Hedder. Yesterday and also the week before, I've heard you, in answering questions of the prosecutors, often refer to documents or other information that you received between 1973 and 1975 from military attachés working for the U.S. Embassy or the U.S. Consulate. Could you expand a little more on the contacts that you had in those days with U.S. military attachés?
If I recall correctly, within the U.S. Embassy context, there was something called MedTech, military something, something, something. I forget exactly what it stood for. By U.S. law, U.S. military involvement in Cambodia was severely restricted in terms of on-the-ground involvement. There were supposed to be no U.S. ground troops, and I think there were certain restrictions on aid and certainly restrictions on advice. So neither ground troops, if I recall correctly, neither U.S. ground troops nor U.S. military advisors were legally allowed in Cambodia. But there was this MedTech part of the U.S. Embassy, or attached to the U.S. Embassy, which the main brief of which I think was the overseeing of the provision of military aid, material aid. Alongside that, as is normal in every American embassy, or almost every American embassy, there's a military attaché, there's an apparatus known as the Defense Intelligence Agency, and those are staffed, like MedTech was, by serving military officers. I think there are sometimes some civilian analysts also attached to those offices, but I'm not sure about that. So I had contact with some of those people, either in MedTech or in the Defense Attaché's office or in the Defense Intelligence Office, with whom I discussed the military situation, and from whom on occasion I got a document or two. If you're going to ask me who those people were, off the top of my head, I frankly don't remember the names. I could try and find out, take a bit of time, but that doesn't stick in my memory, nor in the same way that the name of the Japanese military attaché doesn't stick in my memory either.
Now, if I understand your earlier testimony correctly, you had arrived in 1973 in Cambodia. You worked as a journalist. Would you be able to compare yourself with other journalists then in terms of your access to these U.S. military attachés? Was that something, if you remember, had more in terms of contact than the other journalists?
I would say it was about average. I think some of the more senior correspondents who had much more experience and much better developed and established contacts in the U.S. government realm probably had much better access than I did. I think there were some who maybe didn't cultivate these particular kinds of sources to the extent that I did, and therefore had fewer contacts. But I certainly didn't have special access, nor was I, for some reason or another, excluded or self-excluded from contact with that part of the U.S. official establishment.
Do you remember at the time interacting, or even talking, whatever, with a fellow journalist called Sidney Schamberg?
As you know, Sidney wasn't full-time resident in Phnom Penh. He came and went. I had some contact, but I wouldn't say a lot with Sidney.
So you wouldn't be able to tell from your memory if he had substantial contacts or the same kind of contacts that you had with U.S. military attachés?
No, the relationship between myself and Sidney was not such that that was the kind of information we shared.
In those years, and maybe also afterwards, Mr. Hedder, were you ever in whatever way employed as a U.S. intelligence officer?
The short answer is no.
And the long answer?
The long answer is that in the period between 1979 and 1984, I periodically had research funding from something called the Office of External Research of the Bureau of Intelligence and Research of the U.S. Department of State. And that was on the basis of a contract, which at one point I understood meant that I'd been employed by the Department of State. But subsequently, as a result of some tax matters in my payment of taxes in the U.S. and the U.K., and having to sort that out in terms of my income and salary and so on, it's now clear to me that that shouldn't be understood as employment. It was grant money funding, not salary. It was research as an expert, as it happens, not employment. So, although it's like the same kind of situation that I described with regard to my other research funding. the money comes to your academic institution or through your academic institution, and then you are paid through that route. So it's income, but it's not salary. It's grant, but it's not employment. And the other point that probably is worth making is that it's research, intelligence gathering, intelligence analysis in the public domain. In other words, both the sources and the work product are in the public domain, and therefore it's not covert operations. So in that sense, the U.S. government is one of the three governments from which I've received funding over the years. I mentioned, I think, in earlier testimony, the British government for some of the research that I did at DC CAM. And I was also employed in that sense, but in fact not employment, had grant money by the Thai government, Thai National Commission for UNESCO at one point. So the technical answer is no.
Did you ever, sometime in 2003, submit a book proposal under a working title, Genocide and Auto-Genocide in Cambodia, Communism, Nationalism and Murder, 1975-1978?
I submitted a number of book proposals in that period. I can't be absolutely sure that that's one of them, but it might well be.
Did you, when you made possibly this book proposal, an accompanying remark saying that you researched the CPK for 30 years as a journalist and also as an intelligence officer, quote unquote?
The normal formulation I used was intelligence analyst because that was the rubric under which the grant was made. Intelligence gathering and intelligence analysis. To my recollection, the grant rubric was not intelligence officer, but I may have glossed it in that document. I think another point that's worth making in this context is that Office of External Research, of Bureau of Intelligence and Research, of U.S. Department of State grant money was to do research not on the CPK while it was in power, that is to say, not on the period of the temporal jurisdiction of the court, but on the post-79 period. And in fact, it was part of a larger study that looked at the global situation in Cambodia after 1979. And again, all the results were either published or circulated as academic papers.
Do you know a book from Ben Keenan, called Bringing the Khmer Rouge to Justice? Or rather a chapter in the book, Bringing the Khmer Rouge to Justice.
That one doesn't ring an immediate bell. If I could see, again, if I can see the publication, I might recognize it.
Mr. President, we'd also like some clarification, please. Which chapter from which book?
I'm referring to document D269/5.1, page 225, footnote, in respect of footnote 16. Mr. Hedder, are you
The President. Counsel, please hold on. Judge Cartwright, you may proceed.
Thank you, President. Just a technical matter, Mr. Corpy. This book has a D number. Has it been put before the Chamber, please? And what is its title?
It's before the Chamber. It is, I'm trying to decipher the ERN number. There's a black mark through it. I think it's 004 89660. It is an official D number attached to it. It is on the case file. Here I have the proper ERN number. It's 00488 360.
But has it been put before the Chamber, and what is its title, please?
Its title is Ben Keenan, Genocide and Resistance in Southeast Asia. And it's only in English.
Has it been put before the Chamber?
I have to get back to you on that with that answer, Judge Cartwright.
In that case, could you move to something different in the meantime, please?
I will rephrase my question in more general terms. Mr. Hedder, are you aware that Ben Keenan qualifies you as an intelligence officer?
I don't recall specifically having noted that, but it may well be. And on the basis of the same confusion about the exact nature of the relationship between myself and INR, which, as I explained, is a confusion about whether the contractual arrangement actually made me an employee of the U.S. government or not. The answer to that question is not. In the same way that my funding from the British Embassy here in Phnom Penh didn't make me an employee of the British government, and my funding from the Thai National Commission for UNESCO, which is a state body in Thailand, didn't make me an employee of the Thai government. My exact job title is something that's a bit hazier. As I said, with regard to the INR work, the rubric in the contract, as I recall it, was intelligence gathering and intelligence analysis. And one could summarize that as, yes, as intelligence officer.
Thank you. Let me move on, Mr. Hedder, to an answer that you gave to questions from the prosecution last week in the very beginning. You testified that you applied for a position at the UNAKRT, a position with the Office of the Investigating Judges, and that after you received that position, almost immediately, sometime in 2006, you were detached at the request of Prosecutor Petit to work as an analyst, researcher, or whatever for the prosecution. Did I summarize that correctly, your answer?
Yes.
When you were given on loan, so to speak, to the prosecution, was it clear to you that after a while you would go back to the Office of the Investigating Judges?
It was certainly clear to Judge Lamond. I think maybe Prosecutor Petit had different plans or hopes, and I was caught somewhere in between those two perceptions or persons.
Do you remember, in the light of this specific decision, anything from Judge Lamond in terms of the possibility of a conflict of interest once you would come back to the Office of the Investigating Judges?
If I recall correctly, his view was that the Anglo-Saxons might think that way, but of course they would be wrong.
Do you remember if he gave any arguments to back up this position?
Frankly, Judge Lamond wasn't prone to explain his managerial decisions to his staff with extensive legal reasoning.
When you were working for the prosecution in 2006, before you returned, did you make recommendations to the prosecutors about, for instance, whom to interview?
President, witness, please hold on. Mr. Prosecutor, you may proceed.
I only object at this stage. I've not objected to the previous questions. There have been a variety of decisions about the extent of questioning in terms of other phases of the trial process. I have before me a decision from the 7th of December 2012. The ECC legal framework does not envisage examination by the trial chamber of the procedural correctness of the judicial investigation upon being seized of the case file. It seems to me we're veering into that territory. I'll of course be guided, given what Judge Cartwright said on day one of the examination of Mr. Hedder, but in my respectful submission, we're getting into the sort of territory that Her Honour Judge Cartwright was cautioning against. But I'm of course in the court's hands, but it seems to me we are in that territory, and for that reason I object.
If I may reply, Mr. President, I'm aware of your ruling on this issue. It's not my intention to go into big detail as to the work and activities of this witness when he was employed by the prosecution. I do have a few general questions about sort of the general terms of his work there. So I will not go into any specifics in respect of names of witnesses or just some general questions as to be able to understand the things that he has done in general terms, once again, when he was working with the prosecution.
The President, the objection and grounds for objection by the prosecutor against the last question put by the defense team for Mr. Nguyen Chia is sustained. It is well grounded. and the Chamber wishes to advise the parties that the issue of procedural conflict, it has been addressed by the pre-trial chamber thus far. For this reason, the Council is advised to put substantive question in order to ascertain the truth in these proceedings. You may proceed.
Then my question to you, Mr. President, would it at least be possible to, for the record, have me pronounce the 4 or 5 questions that I have, assuming that you will not allow me, or not allow the witness to answer them, but just for the record, that these questions are known to you.
The President. The Chamber has already ruled on this issue that the objection by the prosecutor is well grounded, and the witness is directed not to respond to this question, and the Council is now directed to put substantive question to the witness so that it is conducive for the Chamber to ascertain the truth, and this will contribute to the interest of the proceedings before us.
I'm just trying, Mr. President, to distinguish the many hats of this witness. The knowledge that he has acquiesced in the various roles that he fulfilled in his life. One last question then, in respect of your position later with the Office of the Investigating Judges. Did Judge Lamond ever ask you only to seek for inculpatory evidence rather than exculpatory evidence?
President, witness, please hold on. The prosecutor, you may proceed.
Same objection, same grounds.
President, if the Council does not have anything to respond, then the Chamber ruled that the objection and ground by the prosecution is sustained. Witness, you are directed not to respond to the last question put to you by the Defense Counsel.
Then I will ask the question again, and I think I'm entitled to ask that question. Mr. Witness, did Judge Lamond ask you only to collect inculpatory evidence and not exculpatory evidence? And anticipating the objection of the prosecution, I think this is a very relevant question.
Same objection, same grounds. Already ruled upon, but I repeat the objection.
President, the Chamber already ruled that the witness, you are directed not to respond to that question.
Mr. Hedder, I will move on. It is still related to that phase in 2006, but it's moving on more in terms of your material. You have testified earlier that you were, in 2006, possibly also afterwards, in the possession of original CPK material, original documents such as the revolutionary flag, maybe telegrams or other original documents. Would you be able to tell us when you got the position in 2006 with the tribunal, that you indeed handed over all your original documents to the investigating judge?
They were offered in their entirety, but they weren't all taken. In other words, I offered everything, but much of it was declined.
More particularly, did you offer original copies, original versions of revolutionary flags? Do you remember specifically giving these documents to the investigating judge?
Yes.
Do you have any knowledge as to where these original revolutionary flags are now? The ones that you gave to the court?
No, I didn't give them. I offered them. They were declined. So I took. They're the same ones that ended up later in the possession of the court. So these documents, among others, were offered. They were declined. So at some point, I took them back to London, and then when the court asked for them, the trial chamber asked for them, then I supplied them.
The reason I'm asking you this question is, or the background of that question is the following. Our client, Nguyen Chia, would really like to see, as it were, to have in his hands an original version of one of the revolutionary flags. Now, you, as a scholar, as an academic who has researched the period extensively, can you tell us how an original version of a revolutionary flag could be placed here, so to speak, not literally, of course, but here in the middle, so that he can see the authenticity, or judge the authenticity of it? Just in terms of general procedure, how to, based on your experience and your knowledge, how to be able to get an original version of the revolutionary flag.
President, witness, please hold on. The prosecution, you may go ahead.
Mr. President, I can't see how it's appropriate to ask Mr. Hedder how this could be shown. Two documents were shown yesterday in red. They're on the case file. I gave the file numbers. I don't understand why this line of questioning is being pursued. The red flags that they are on our case file. The red ones on our case file with a case number. Why are we asking how does Nguyen Chia access it? Press a button on the computer and it comes up on the screen. What's the problem?
Mr. President, I'm just trying to make the witness understand the background of my question. The question is about, but let me rephrase it. Mr. Witness, could you explain how in your research and the writing of your academic articles got into the possession of these original revolutionary flags?
As I think I explained, when I came to the Tuol Sleng Genocide Museum, which I did first in late 1980 and then again in 1981, but I believe all of this happened on the first occasion, I was shown by the then archivist a collection of revolutionary flags, revolutionary youth, and some other, evidently, original CPK documents. And in the situation where there was no photocopy facility available, they decided to give me originals from that collection, of which there were other originals. So they gave me those originals, and then in 1981, and then on numerous subsequent visits to the Tuol Sleng Genocide Museum, I made photocopies, once photocopying was a technical possibility, of all the other revolutionary flags, stroke flags, and revolutionary youth that they had in their possession. I'm trying to think whether there are some photocopies in my files which came off of revolutionary flags or revolutionary youth that are in the possession of DC CAM. I don't specifically recall whether those are photocopies of originals or photocopies of photocopies. The upshot of all of this is that in addition to the ones that I eventually, having previously offered them and then been told they weren't needed, having eventually been asked by the trial chamber to provide the two, I take it, missing originals, I provided those too. I'm pretty sure that I didn't get rid of the other originals in my possession somewhere along the line, so they're probably somewhere in those 45 filing cabinets of paper materials that I have on various aspects of Cambodian politics, including the Khmer Rouge. So if there are missing editions, in theory, with sufficient time, I might be able to find them.
When was the last time that you had in your hands physically documents like those revolutionary flags or S-21 confessions, and particularly the ones with the alleged annotations of Nguyen Chia on it? Do you remember when you had those physically in your hand?
Well, I would have brought them with me to Cambodia in the middle of 2006. I recall the presumption having been at the Office of the Co-Prosecutors that other originals were available in other locations, and therefore they would be obtained from other locations. When I first went to Office of the Co-Prosecutors, I offered these documents. They were declined. When the introductory submission came in the middle of 2007, is it July 2007, the introductory submission? They were offered again and again, declined. So I probably brought them back to London maybe around Christmas of 2007, the next time I went to London. I don't remember exactly when, but most likely sometime in the latter part of 2007, I packed up all the stuff that I had brought that hadn't been taken or copied either by prosecution or the Office of the Co-Investigating Judges, and took it home and put it back in the filing cabinets.
You've testified and also written that you have extensively studied S-21 confessions. A very concrete question. Do you know, on the basis of your research and your academic writing, where exactly the S-21 confessions with the alleged signature of Nguyen Chia, where they are physically situated?
I think the answer to that is no, because I'll back up to your earlier question. Among all those documents, there are very, very, very few, documents in my possession. There are very, very, very few that are original S-21 materials. The archivists weren't happy to leave any of that stuff leave the building. On a couple of occasions when there were like 7 or 8 carbon copies, they gave me one of the carbon copies. But 99.9% of the S-21 confession material that's in my possession is photocopies. So originals, either I have never seen or I don't know where the originals are, and I've only seen a very few of them. Other than, I saw the originals that were filed in the Dual Slaying Genocide Museum, and many of my copies are copies from there. But those, generally speaking, from what I have seen, are not the ones that are annotated. The ones that are annotated come, to my knowledge, from a different location, not specifically or directly known to me, than those that were originally on file at the Dual Slaying Genocide Museum.
Just to make sure that I understand your answer, the 15, 20 plus confessions with a signature allegedly belonging to Nguyen, the whereabouts of the actual originals you do not know.
Thinking about it again, if I recall correctly, on the case file, there are color scans of said documents. And my recollection is that I did some of those color scans myself while at the Office of the Co-Investigating Judges, but on the grounds of DC Cam. So at the point in time when I did those color scans, the originals, if I recall correctly, from which I made the scans, were at DC Cam. Doesn't mean they were necessarily stored there. They were brought to me in a photocopy room, or I used a scanner that was a photocopier to do the scans, and then they went back to wherever they came from. Where that wherever is, I don't know.
And would you be able to tell how you were able to determine whether these specific confessions with that signature on it were in fact authentic and original versions?
President, witness, please hold on. The prosecution, you may proceed.
It seems to me that's an expert opinion question. I object.
I'll rephrase. When you saw those documents that were handed to you, did you do anything in order to come to some assessment of its authenticity?
No.
I might come back to this subject, Mr. Head. Let me move on to the next subject, and that is something. That's an answer that you gave earlier in your testimony to a question of the prosecution, and that is the interview that you apparently had with K. Pok. Now, if I remember correctly, this material in the interview was you were allowed to give that free once K. Pok had died. As I understand as well, you tried to offer this material to the Office of the Co-Investigating Judges. They didn't want to accept it, and now it is stored, literally you said, somewhere in your 45 cabinets in London. Do you remember what was told to you when you offered this specific testimony, as I might call it, of K. Pok to you?
President, witness, please hold on. The prosecution, you may proceed.
Mr. President, really, it's a twofold objection. One, going back to the direction that the trial chamber's not interested in what judges said or didn't say, or what OCIJ said about material that was being given, is the first point. And the second point, again, just simply on relevance. What's the relevance of what somebody said about some piece of evidence that's not on the case file? How does that assist you in determining the truth?
I'm just trying to establish, Mr. President, what exactly happened to the alleged testimony of Kapok. We have been speaking extensively about the interviews that Ing Sari and Kirsapan have given to the witness. There seems to be an interview with Kapok, but we don't have a transcript as we have when it comes to the interviews of this witness with all these other people. So I'm trying to find out what happened, and I'm trying to find out why, or if the witness has any knowledge as to why nobody seemed to be interested in this particular testimony.
President, I'd like to give the floor to Judge Zamala Vange to respond to the objection to the last question. Judge Lavange, please take the floor.
Yes, thank you, Mr. President. The Chamber would like to note that the Kapok's interview is an element of evidence which has been placed on the file, so this element will be considered. The question is, why wasn't this element placed on the case file during the investigation? Well, this question does not seem relevant, so we should move on to another topic.
With all respect, I didn't ask anything about placing on the case file, but I'll move on and ask the question more specifically. I'm referring to document E190.1.398, ERN number 00661459, and that is your footnote. It's your article reassessing the role of senior leaders and local officials. And in that footnote 14 that the prosecution has been referring to earlier, you speak about the interview that you had with Kapok. Then going back to this particular footnote, and I quote from that footnote as follows. In an interview with the author on 22nd of February 2001 in Siem Reap, Cambodia, Pok agreed to discuss evidence against himself and others on the condition that his remarks not be made public while he was alive. He conceded that as a secretary of the CPK North, later Central Zone Committee, he had implemented a CPK policy of killing Khmer Republic officials, initiated the arrest and ordered the execution of, alleged traitors among CPK members subordinated to him, and followed orders from Nguyen to assist in the arrest of other alleged traitors in the CPK ranks whom he knew would be executed after interrogation by the CPK Security Service Headquarters S21 in Phnom Penh. This footnote in your article seems to suggest that this is, at least in that particular footnote, the only evidence used by you to establish a possible link between a policy to kill and the role of Nguyen Chia. Would that be a fair summary of that footnote 14?
President, witness, please wait. The prosecution, you may proceed.
The next words talk about corroboration, and in order for this question to be properly placed in context before Mr. Heder, there needs to be reference, in my respectful submission, to the next sentence and the word corroboration, and identifying where the corroboration was from and whether the corroboration went to the element of the question. It's wrong to suggest to a witness that something is not corroborated when the next sentence talks about corroboration.
I think this witness is perfectly capable of correcting me if I make a wrong suggestion when it comes to a footnote, first of all. Secondly, I would like to remind the Chamber that when my learned friend was quoting extensively from a passage of an interview of Khieu Samphan, he left out the very last sentence referring to Is Som Kadwe Heng Samrin. So now to express a problem with me not quoting the complete footnote seems to be quite odd, I might add. So it is a footnote, it's about a footnote that this particular witness wrote in an article, and I'm sure he's able to assist the Chamber and the defense in answering the question whether the KPOC testimony was the only testimony relevant to a possible role of Nguyen Chia.
President, witness, you may now respond to the question put to you by the Defense Counsel. However, the Defense Counsel and other parties should be reminded that names of other witnesses shall not be pronounced during your questions, except the pseudonyms that have been used, that have been allocated to those witnesses. And that is the general practice for the questioning time. If the witnesses bear their pseudonyms, please use the pseudonyms instead of the actual names.
Sorry, could you repeat the question?
Of course. I just read you an extract from the footnote 14 of respect of your article reassessing. My question reformulated would be whether KPOC was in fact the only source for your for the paragraph in your article that there was a link between a policy and to kill and target law and order officials and soldiers and the possible role of Nguyen Chia.
I mean, the obvious answer is that whatever is said above footnote 14 is based on whatever appears in footnote 14, which is not to say that there might be evidence elsewhere that's not included in the footnote that speaks to the same issue. which was left out of the footnote or which was not in my possession at the time the piece was written. But yes, of course.
I'd be happy for your memory to read the paragraph that this footnote is referring to.
Mr. President, every time I put a footnote to Mr. Hedder, he had the full document in front of him. Can he please be shown full documents and not just have them put up on the screen? This is important evidence, and in my respectful submission, Mr. Hedder should be given the courtesy of being given this document in hard copy so that he can follow the questioning.
I'd be happy to do that, Mr. President.
President, court officer, could you deliver the document from the counsel for the witness examination?
Again, I mean, I can only say that I must have considered this, to use loosely the legal phrase, but only in an academic sense. This was the best available evidence that I had at the time to substantiate the conclusion or the assertion that's contained in the sentence that ends with footnote number 14.
Hence my question, if you remember, why nothing was done with your offer to give that the transcript of that interview. But I will move on, Mr. President. I'm mindful of the time. I'm going to questions of methodology now. It is 10:30. I'd be happy to move on, but I'm in your hands, Mr. President.
President, thank you, counsel. The time is appropriate for a short break. We will take a 20-minute break and return at 10 to 11. Court officer, could you assist the witness during the break and have him return to the courtroom at 10 to 11?
Some change, Counsel.